Welcome, everyone, to the Federal Bar Association Ketam Sections, The Rounds FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy FCA decisions and developments. I'm Scott Oswald, Programming Chair of the Ketam Section, here with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, hello.
Hey, Scott.
Today, in this special edition of the Rounds, we're covering two cases recently decided in the wake of the Supreme Court's decision in Polanski versus Executive Health Resources. But first, let's turn to a case out of the Second Circuit, U.S. XRL Weiner versus Siemens, which deals with the tension between 31 U.S.C. 3730B2's requirement that a Ketam complaint not be served until the court orders service and Rule 4 of the Rules of Federal Civil Procedure, which requires service within 90 days. Tejinder, what happened here?
So this is a case that was originally filed in 2012, and then it sat under seal for years while the United States and the state of New York figured out what to do. By 2015, it was clear that only the federal claims remained. The state claims were dismissed without prejudice, but then the case continued to sit. Then eventually the district court said, okay, I'm going to unseal this, issued an order unsealing it, but didn't docket it, I think, until 2020 or so. And then said, years after that, what's going on with this case? At which point the relator said, well, whenever you order me to serve the complaint, I'll go ahead and serve it. So it'd been 9 years sitting. And so then the district court said, what? And the case was dismissed for improper service of process on the defendant's motion. And so on appeal, the relator said, look, the statute very clearly says that I cannot serve the complaint until the court orders me to serve it. The district court didn't order me to serve it, so the time to serve had not yet started. And the Second Circuit agrees with the relator. The Second Circuit says the plain language of the statute is clear. It says the complaint cannot be served on the defendant until the court so orders. And so the time to serve under Rule 4 doesn't begin until that order is entered. The defendant argued, actually, the order unsealing is tantamount to an order ordering service. And the Second Circuit said, no, it's not. Those are two different things. Although they are often entered concurrently, they weren't in this case. And so in the future, you would want to do that. There is a second basis on which the defendant sought dismissal, both in the district court and on appeal, that was denied. And that was for failure to prosecute under Rule 41. The district court said, well, the plaintiff didn't have any notice that that might happen, and so that would be an extreme sanction. And the Court of Appeals said, you know, in this case, it probably would have been okay for the district court to dismiss on that basis, but because we're reviewing this for kind of abuse of discretion, we don't think this is the extreme case where dismissal is the only permissible remedy, and so we're going to affirm the district court's denial on that basis. But for anybody who's thinking about this case and these issues in the future, that does remain a possible grounds for dismissal, even though insufficient service would not be.
So let's talk about the practical implications of this, Tejinder. What are our takeaways for each side?
I think that what really ought to happen from now on, and hopefully district courts will just do this on their own, is they ought to enter an ordering service at the same time as they unseal the case. If they don't do that, then I think it behooves relators now to request an order commanding service so that they can get the litigation underway. Relators wouldn't want to end up being on the wrong side of the statute by trying to serve a complaint when service is prohibited, and they don't want to sit around for months and months because then they open themselves up to arguments under Rule 41. So I think in the future, what ought to happen is district courts and relators ought to be diligent in pursuing service upon unsealing, which is, I think, more or less what has been going on. But if it doesn't happen for some reason, relators can take some solace that they can't get dinged for improper service until that order is entered.
Let's move on to the U.S. District Court for the Northern District of Alabama with U.S. XRL Wallace versus Exactech. This is a case that has attracted a ton of attention, including a statement of interest from the Department of Justice, because it features a test of Justice Thomas's recent musings in Polanski versus Executive Health Resources about the possible unconstitutionality of the qui tam provisions of the False Claims Act. Tejinder, the stakes are high because the defendant contends that the qui tam provisions of the False Claims Act violate the Constitution's Appointments Clause and the Take Care Clause. What did the court say about whether relators are officers for purposes of the Appointments Clause?
Yeah, so the court reaches the merits of these challenges and rejects both of them on the merits. On the Appointments Clause question, the court says that if you are to be an officer of the United States, you have to have there's a test for this. It involves whether you exercise government power, whether you have tenure, a duration, continuing emolument, or continuous duties. And that test is from the Supreme Court cases. And what the court says is relators are really one-off participants in their own civil cases. They are not officers of the United States and therefore do not need to be appointed in accordance with the procedures that govern the appointment of officers under the Supreme Court's precedents. And so that's really how it disposes of the Appointments Clause challenge. It rejects the argument also that under the Supreme Court's decision in Buckley versus Vallejo, only officers can sue in the name of the United States. It says, no, there's no problem with that. Nothing makes the United States the exclusive enforcer of federal law.
Let's turn to how the court comes out on whether the government exercises sufficient control over decline litigation such that the qui tam provisions don't offend the Take Care Clause. How did the court come out on this score?
So the same way, in essence, what the court says is that private parties can enforce federal law. Of course, we know there's lots of examples of federal statutes that can be enforced by private plaintiffs. And then it goes through the precedents about the Take Care Clause, including Morrison versus Olson, and similar precedents, and says, look, this FCA is different. It's different for a variety of reasons from statutes governing, for example, the appointment of the independent counsel, because, again, this is a lesser degree of power. These are just civil litigants, kind of like any other. And to the degree the federal government can be involved, it actually exercises more control over these cases than ordinary civil litigation under federal law. And so the court points, for example, to the government's power to intervene in the action, to dismiss the action, to settle the action, and to otherwise participate in the proceedings, whether it intervenes or not, and says these indicia of control are sufficient to make the FCA constitutional. The court also points out, and this really relates to both challenges, that there is a strong argument from history that the FCA is constitutional. Qui tam statutes existed at the time of the founding, and they've been around since. And so the court says that's really strong evidence in favor of their constitutionality, which is, of course, part of what the Supreme Court itself said when it deemed relators to have Article 3 standing in the Stevens case.
So the District of Arizona took up a same challenge in U.S. ex rel. Thomas versus Mercy Care. And here too, the defendants claimed that the court lacked subject matter jurisdiction, contending that the qui tam provisions of the False Claims Act were unconstitutional. But here, the District of Arizona simply turned to its binding precedent in U.S. ex rel. Kelly versus Boeing Company, a case going back to 1993. Tejinder, tell us about Thomas versus Mercy Care.
Yeah, this is a case where the constitutional arguments were really raised kind of in a very cursory fashion. And the district court basically gives it the back of the hand, says you didn't really make much of an argument here. And even if you had, there's binding Ninth Circuit precedent that dictates upholding the FCA. I'll note that in the Exactech case, it was an open question in the 11th Circuit whether the FCA was constitutional, which is why the district court probably went through as much analysis as it did. But the court did note that in every circuit that has considered the question to date, the circuits have said it's constitutional. And the Ninth Circuit, where the District of Arizona is one of those circuits. So it was really open and shut question in the Thomas case.
So considering the results of these two cases, where do you think this debate goes from here?
I've always thought that the way this debate is going to shake out is that we are waiting for one court, whether it's a district court, but really ultimately a court of appeals, to deem the statute unconstitutional. Once one court of appeals deems the statute unconstitutional, and if that decision is not revisited en banc, you will see the Supreme Court weigh in on this question. Until that time, though, I would expect the status quo to remain intact. That is to say, courts will say the FCA is constitutional. The Supreme Court will not visit that question absent a circuit split or a circuit deeming it unconstitutional. And so I would expect us to have the status quo that we have had since the 1990s when these arguments were first aired out until that happens.
Tejinder, thank you. And thanks to each of you too for joining us for our final edition of the rounds with Tejinder Singh for 2023. We look forward to seeing you again in the new year.